Hello and welcome again to Jaded Law Channel. As always, this remains that law-based channel where your legal needs are met, where your questions are answered, and of course your issues are adequately resolved. I remain your host, Mrs. Omonigo Ube. I recall in one of the videos on wills that I actually promised that I was going to address this issue. I had mentioned that there are people who, for one reason or the other, still don't feel comfortable. The thought of preparing a will just doesn't go down well with them. Are there options should these people be desirous of transferring their interests in a property to a friend, a relative, a child, or an organization? Are there options if these people don't want to do it through the instrumentality of a will? That's what we'll be addressing today. But before we go any further, I want to ask you a simple question. Have you subscribed to this channel? If you haven't, please do so now. All right. Now, there are people who are not just comfortable with the thought of preparing a will, but they are desirous of having their properties or a property transferred to a loved one. Is it possible for them to do that? The answer is yes. Now, there is another legal document, and this document is referred to as a deed of gift. What is a deed of gift? A deed of gift is simply that legal document by which a person known as a donor transfers his interest, transfers his title to a property to another person referred to as a donee or a beneficiary. And one major difference between a will and this document, that's the deed of gift, is the fact that while in a will, the beneficiary can only begin to enjoy or take advantage of the will upon the death of the testator, in a deed of gift, the donee or the beneficiary takes immediate possession. What I mean by this is that a deed of gift becomes operational upon execution. Once it is signed, it becomes operational. The beneficiaries can take advantage, they take possession of the property. That is one major difference between a will and a deed of gift. Now, while a will can be challenged, and I'm sure in one of the videos, if you've actually watched it, I mentioned that there are times wills can be challenged, and I also talked about measures to be put in place to ensure that even when challenged, that the beneficiaries still have access to what the testator left for them. Okay, so you can go back and watch that video. So while a will can be challenged, it would be very foolish for anyone to challenge a deed of gift. And the reason is simple. The person, the beneficiary or the donee, would have taken possession even during the lifetime of the donor. So what are you challenging? Okay, it would just amount to an exercise in futility for any person to even attempt to do so. So this is also one major difference between a will and a deed of gift. All right, so for those of you who are not comfortable with a will, you have an option. You can have a deed of gift prepared for you. But because of the legal issues that accompany deeds of this nature, it is advisable that you seek legal counsel from your lawyer. I'm sure you've learned something today. Ignorance of the law is no excuse. Take advantage of every opportunity to learn something. And I believe we're doing that in this channel. Thank you so very much. Please get your friends, your neighbors, and everyone to subscribe. I look forward to seeing you next week. Please stay safe and be good. God bless you.